let's first go to Tae about sort of the language, right? Because some marijuana laws refer to impairment, and then sometimes they refer to under the influence. Maybe they mean the same thing, or maybe not, but it does, beyond the issue of impairment, put employers in sort of a new position, right? Because for years, drug testing's been about identifying, somebody who's got drugs in their system and then maybe punishing them for that, or some type of adverse employment action. But now we've got lawmakers at the state level throwing around terms like impairment or under the influence, et cetera, and maybe meaning the same thing, maybe not always meaning the same thing, but it does put the employer in a position of trying to figure that out. From a legal perspective, how would you respond to that?
Yeah, I mean, I think the problem is you go back historically, right? In the good old days, right? Pre-pot, a positive drug test, you could just take whatever action you wanted by and large because there were no protections for whether it be a marijuana user, a cocaine user, the list goes on and on and on. So just the drug test itself was sufficient to take action, irrespective of whether or not the person was impaired or not, because as we all know, a drug test doesn't measure it. And the problem is that now you have all these marijuana legalization laws, all of which say completely different things, by the way, from state to state. And our wonderful, lovely state legislators in all their glory, they use this word impairment, and under the influence, you can use those sort of interchangeably, but they use this word impairment, right? And they say in some of these laws, you can't fire somebody because they use medical or recreational marijuana, whatever the case may be. And then they go on to say, well, you don't have to let people be impaired at work. And I guess none of these legislators have either ever A, smoked pot, or B, been drug tested, because they don't understand that there's a challenge in understanding whether or not someone is or is not impaired, right, under old technology. And so from a legal standpoint, you've got employers who are trying to deal with a very difficult issue of establishing impairment to try and avoid some of these marijuana laws. But historically, there's been no way to measure impairment. And so I think that the ability to establish impairment checks a lot of different boxes, right? It checks a legal box, it checks some practical boxes, it checks some risk management boxes. And taking those one by one, as you said, Bill, a lot of these marijuana laws, they say, hey, you don't have to comply with this law if the person is impaired. And so if you can establish impairment, then bang, you've got sort of an easy defense that you can assert in defending some of these legal claims. In addition to that, from a risk management standpoint, if you can establish impairment, then you are going to dissuade claims from being filed against you to begin with, because, think about it from sort of the practical aspect. What plaintiff's attorney or what employee is going to try and fight an uphill battle of trying to assert an employment-related claim when they're impaired, right? And if you can say, look, here's the test. We hooked you up to this device. It says you're impaired. What do you have to say about that? Then that's going to dissuade your risks, and that creates risk management just in general, in addition to creating that legal defense to some of these various claims. And then I always like to think when I'm advising clients, look, I can tell you the law, and the law is great and wonderful and blah, 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 but you still have to run your business. So you got to think about what are the stakeholders in your organization saying, what do they think, what are they trying to achieve? And I think that internally within organizations, we have a lot of different voices that are saying different things and that may have different opinions about marijuana, whether it is the HR people who just want to hire people and they may care a lot less about marijuana. You've got the in-house lawyers who are just trying to reduce risk. You've got environmental health and safety, and they're obviously the ones that are the least tolerant towards marijuana. You've got CEO, you got COO, but anyway, you have all these different buckets of people. And I think that irrespective of what all of those people think when it comes to marijuana, I think all of them agree we don't want people to be impaired at work, because people being impaired at work can create safety issues, it can create performance issues, and we just frankly don't want somebody who is so stupid that they decide to smoke weed and then come to work. So we all collectively want to prevent people from being impaired at work. And so if you can find that technology that establishes impairment, then all of a sudden you've not only got the legal defense, you've got the risk management tool, you also have the thing that will check the box for all of your internal stakeholders, because you all of a sudden now have the ability to prevent actual impairment at work, right? I hear from clients all the time, we don't care what, Ken and Linda and Bill, we don't care what they do on the weekends. We don't care what they do with the Grateful Dead concert on the weekend, but we do care about what they're doing at work. And so if you have the ability, again, to measure that impairment, then it begins to check all the different boxes that you want to check, not only from the legal standpoint, but also from the business standpoint. So Bill, I know I got way off on a tangent there, but I think that the bottom line is the ability to measure impairment is the white whale that I think most employers have been looking for.